How do you pronounce your name?
My surname is Le Grange.
Le Grange, I thought so. Okay. I had Judge Gembro refer to you as Le Grange, and I thought, or something like that. Okay. How are you?
I'm fine, thank you, Chief Justice. And how are you?
Good, thanks. I must just apologize for keeping you waiting for so long. We were a bit tardy in the first step of the proceedings. But I doubt very much that you will sit there for as long as the previous candidate. This is a silent plea to the commissioners. You hold 3 academic qualifications in the legal field. A B.Juris you obtained from the University of the Western Cape, right?
Yes, I've obtained my B.Juris and my LLB.
And the LLB.
And then my BCom Honours at University of Cape Town.
All right. You started out in the Department of Justice as a public prosecutor in 1988.
That's correct, Chief Justice.
Mm-hmm. Then in 1993, you joined the magistracy as an additional magistrate and worked your way up to regional magistrate by 1998. How long were you a magistrate?
I was a magistrate for 5 years and a regional magistrate for 8 years.
All right. Then you started acting as a judge in the Western Cape Division of the High Court.
That's correct, Chief Justice.
In 2005. You acted for 2 years straight?
Except for the recess periods, but approximately 2 years, straight years.
All right. But then in 2007, you were appointed permanently in the division.
That's correct.
To date.
Yes, Chief Justice.
You were appointed as acting deputy judge president in April last year.
Yes, Chief Justice. You
still hold that position?
Yes, I still hold that position, and my appointment is until the end of this term.
What kind of functions do you execute in this capacity?
The acting judge president has given me specific functions, and that is to deal with the criminal division and also to deal with all matters falling under that division, namely petitions that come to the court in terms of Section 309C, where I will then allocate these petitions to the different judges. I will also allocate criminal matters to the judges. I'll deal with the circuit courts, and I also deal with surrogacy matters and any other matter which he deems fit to send to me for management, whether it be litigants or practitioners that seek directives from the Office of the Judge President. I will deal with that.
And I take it you have enjoyed the experience, because here you are in front of us.
Well, it was interesting and also hard work, but yes, here I am.
Okay. Assuming that you have a vision for the court, what you'd like to change, improve, or, I don't know what you have in mind for the court. Would you just take us through what's in your mind at night when you think about your day and how the future should look for that court?
Chief Justice and Commissioners, I've been at that court now for almost 19 years, beginning as a junior judge, then as a senior judge, and now in a leadership position. I am of the view that, and I think the Commission is well aware of the difficulties that we've gone through in that division. My vision for the division is a short-term vision, a medium term, and also a long term. In the medium term is a period of starting off until about 6 to 12 months, Long term is about from 12 months to 24 months, and obviously a long-term vision thereafter. I've got about 8.5 years left before retirement, and I would like to build a court that is stable. I would like to see a court that delivers quality justice and access to justice. And I would like to see a court that embraces new technology. I would also like to see a court that do things a little bit different, because in terms of approach and in terms of views, obviously I've got a different approach and different views as the AJP, and that is why I'm sitting here today. With regard to my short-term vision, there is no magic wand in regard to build a division that had all these problems. But one can at least start somewhere. And somewhere where to start is to have an open debate amongst the colleagues within the division. And I firmly believe that being there for so long has given me an insight into the division. I know the division like the back of my hand. I know the administrative side. I know the officials that work in that division. I know the legal profession that practice there on a regular basis. I interact with the various organized profession bodies on a regular basis. So I've got a deep understanding and the complexity of the division. And for me, one of the issues to do in a very short term is, for instance, to have a weekend away under the auspices of Judge A, so that we as colleagues can have an interaction within a private environment, confidential environment, and have a one-on-one talk. Because I don't know if it was mentioned by the AJP previously, but when she started, it was the first meetings that we had last year in about 6 years as judges. We never had meetings before. It just suddenly stopped. So the issue is, how can you run a division effectively if you don't have judges' meetings? But more importantly is to have not only judges' meetings once a term, but often as possible, so that we can have debate, raise, because judges have always got different views and perceptions, and we need to talk about it. It's only then that we can learn from one another. So that is the first thing that I will do, but it will not be once off, because we need to build a team. We need to continuously build in terms of our collegiality, in terms of how we see things and how we're going to do it. That's the first thing that I will do. The second thing I will do is change the way we allocate our matters. We still have an old system of manually allocating matters to judges. And it's not as we don't have the capacity or the technology, it's there. So what we need to do to dispel this notion of there might be unfair allocations, or somebody get more work than others, or I saw somebody walking in the corridor not being in court. The simple solution, as far as I'm concerned, is to have a program. We go on OneDrive, and a judge that wants to see what he or she has been allocated, click on the laptop, open up, and can see what they've got for the day or for the next 2 weeks, what Judge A has got, what Judge Y has got, and so forth and so on. Those are the things that I will immediately introduce. In terms of my interaction with the judges, I've got no controversy with any of my colleagues. I've got an open door policy. In fact, I'm sitting here today because a number of colleagues, junior and senior, has came to me before and said, please put up your name. Not only that, I had the support staff coming and ask that I must put up my name. I've also had, as you can see from the nomination letters, people from the legal practice or the organized profession, to put it that way, that said I must put up my name. And I think that the reason for that is as a result of my interaction and the respect that I've gained during this period of time on the bench, not only from the organized profession, but also from the public in general, and also from my colleagues at large. In terms of my medium plan, our court currently functions on paper. So if you want to file a document, you must file it at what we call room 1. Our storage facility is limited. We don't have sufficient storage facilities anymore for those files that's there. So from that perspective, what is the solution? Case on lines. We have been introduced to it. We have had our training, and Judge President Malambo was so kind to come out one Friday, and we were sitting from 2 o'clock until about 5:30 to train the judges as to how to use case lines. And that is the answer. So we can go electronically, the attorneys and the public can file it electronically. It will assist on more than one level. It will assist that we don't have to worry about files getting lost. It will assist where parties blame one another for not filing timelessly, because once a document is filed, it's there, it's up. So that for me, in the medium term, that is from 6 to 18, 24 months period, that should be introduced within the Western Cape High Court. And I will drive that particular process. With regard to my long-term vision, our division currently relying on acting judges. And I've supported the AJP with regard to compiling a list for candidates to be appointed as acting judges, because we have got 5 vacancies currently. And our establishment is 33 judges. So currently we've got 28 judges, of which 1 has been recently recommended to the Supreme Court of Appeal. We've got 3 judges that's going to retire within the next 18 months. Collectively, if you take into account the judges that already retired in the past 4 to 5 years, those that are going to retire in the next 18 months, and those that have been elevated to a higher court, we have lost about 200 years of judicial experience. We need to get judges, permanent judges. Now, with regard to the acting judges, and this also impacts on the reserve judgments, is you get those that has got no interest in permanent appointment, that are only there to help and assist with backlog. Then you've got those acting judges that's not sure whether they've got the temperament of a judge. I would like to experience a term or half a term to see whether they have it, what it takes to be a judge. And then those acting judges that tells you up front, I would like to become a judge, therefore I would like to come and act. So those are the scenarios that we've got. And we've also got the pro bono system in place. For me, it is how do we go about appointing the acting judges? And what are the criteria that we are using currently to get the people on board? in terms of the transformation, in terms of gender transformation, and an overall perspective of getting people that can also do the work. And in that instance, I will, if I do get appointed as a medium-term vision of mine, is to get more input before appointing acting judges. In order to go to the judges, the permanent judges, say, I've got a list, I've got 9 acting judges that I need to appoint for next term. Here are the list of 15 people. What's your input on that? And from that discussion, whether they want to talk in a meeting freely or whether they want to come and see me personally to say, yes, this person has appeared before me or that person has got an issue, then I ultimately will make the final determination. So from that perspective, we have to look in terms of how we're going to go about. We can also not only limit the acting judges to advocates or to attorneys or only to magistrates. The academia is there. Some of these practitioners are professors. They are expertise in the field and would like to come and act. And we need to have that in order to give them an opportunity. And some of the CVs are there, but they don't get appointed. So those are the things that I will change, and that's part of my vision. And let me put it, it is practitioners of color. They're not white. But more importantly, in terms of the long term, my vision is we need more judges. That's as simple as that. Our workload has increased tenfold since I became a judge in 2007. But our precinct is old and is very compact, if I can put it that. So we need more courts. A building has been in the past identified. That process has stopped due to lack of funds. So there was previously mentioned that we will be able to get 2 courts probably, civil courts. And that is a long-term plan in terms of funding. But in terms of the criminal division as well, our caseload has quadrupled in the past 5 to 6 years. We are sitting with people in prison awaiting trial for almost 2 to 3 years before they get a trial date. I've visited, in the past 18 months, various prisons. And I can tell this commission that if you walk into one of those awaiting trial facilities, they're overcrowded. You've got 40, 50, 60 people crowded in one facility with an open bathroom, sitting there for a year, 2, 3 years, waiting for a trial date. That cannot be. So what I have done is, there was this program before where we used courts at prisons, and one particular court, Paulsmoor, but there was some sort of objection from the practitioners and whoever, the facility was not up to standard. I took it upon myself. Took the stakeholders to Paulsmoor. We had the commissioner, he retired now, with us. I asked the legal profession, what is wrong with this? Why can't we not sit here and deal with matters? And they were telling me that this bench is too short and we're sitting on top of each other. And the commissioner said, stop. What do you want us to do? Do you want us to lengthen it? Yes. So how many council can sit here? From 4, we increase it to 7. And that's been done. Paulsmoor is running currently. In the past 12 months since I took over, 6 matters has been finalized in Paulsmoor. And these are not 6 ordinary matters. They are 6 highly complicated and high-risk matters. With regard to Goodwood Prison, that prison facility was not up yet. I've pressed the Department of Correctional Service, then under the previous commissioner retired, to get the facility up and going. It is now. But we have got a problem in terms of the IT infrastructure, because the cabling is too expensive and no one has got money for it. So we are using our own mobile system currently. 6 matters has been finalized in that court in the past 12 months. So these are the things that I would like to drive, and to see more of these facilities, because we need to finalize cases. The turnaround of cases needs to increase. This commission will probably know, and I've got a report here from the NPA, that essentially says that currently the Western Cape High Court has got 13 high-risk matters. The commission has probably read in the newspapers about it, but when you see the witnesses under witness protection, it's one thing. But when you see the investigating officer under protection, and you see the prosecutors under protection, it's something else. And whilst the cases are running, witnesses are being taken out. It's a worrying factor, and we need to deal with it. Because if we don't do it effectively and efficiently, the rule of law will be under attack. And that is my vision, that to get the division running smoothly, and currently I can say to this commission that from 197, I'll just get my figures right. About 2 years ago, we've now got about 110 matters on our roll. Of that 110, 34 are parted matters. So there are some judges that's got more than one parted matter. 14 of those matters are currently in sentencing stage. So we will be under the 100 mark of criminal cases on our roll. And how did we do it? I physically went to go count those cases, because in order to manage it, you must measure it. Because without that, you don't know what you're doing with and dealing with. I've also indicated to the judges, because what we found is the acting judges not completing their cases and their criminal matters. And then they postpone the cases to term. So when we arrive after recess period, we find that most of the courts are busy because this acting judge is doing criminal matter and that acting judge is doing a criminal matter. I stopped that. I stopped it. I said, no. If you've got a parted matter as an acting judge, criminal matter, you do it in recess. And if those judges, permanent judges, can finalize a criminal matter, whether just to sentence, or whether there's a probation officer's report outstanding, do it in recess. And that is what I've done within the short space of time. And I think that I'm confident that I've got the backing of the judges with me. Not one of them has raised any issue with me yet to say that they disagree with this or they don't agree with that in terms of the case flow management of cases. In terms of being a judge president, obviously you must also have your pulse, or your finger on the pulse in terms of the rest of the division. What's happening in the lower courts? What's happening in the organized profession? And in that regard, my interaction with the magistracy, I understand the issues there. I've been a magistrate. The regional court president was the other day at her office, and we discussed the issue of the Southern Cape. Southern Cape has got a problem in the regional court. There are only 5 magistrates, but there are about 4,000 cases outstanding. We need more magistrates to work down that load. So that is work in progress as to how we're going to deal with that. In this past 18 months, I could not give sufficient attention to all what's happening in the lower courts because of what was required from me to work in our own division. But I've understand the difficulties that they're facing. Infrastructure problem, recording machines that's not working, and how that impact on the delay of cases. So from where I'm sitting, Chief Justice and Commissioners, is we need to build the Western Cape. We need strong leadership within the Western Cape. And we need leadership that can understand the issues of the Western Cape. And I firmly believe that we can, or I can turn it around with my experience and skill set. The last thing that I would like to mention in terms of the bar, because that always remains an issue. We see that young black junior counsel coming in, but after a few years they disappear. The Cape Bar has got what they term a program where from year 0 to 5 you will have senior counsel clubbing together in a pool and pay the expenses of the young juniors. But that's only from 0 to 5. The difficulty is after 5 or 7 years, what happened then? That is where the problem lies. And often, the briefing patterns of the state needs to be looked at. It cannot be that you still find today that the state brief, and I'm saying with all due respect, white males walking into your court without any juniors or black juniors. Why is it still happening? The state attorney might have his own briefing patterns, but we need to relook at that. And I think if that changes, that we have a system where senior counsel must have a young black counsel, female, male, then it will assist in the transformation of the judiciary. Because I firmly believe a strong and ethical bench and attorney's profession brings about a strong and ethical, let me just rephrase that. I just want to say a strong and ethical advocates bar and a strong and ethical attorney's profession brings about a strong and ethical bench. Thank you, Chief Justice.
Thank you, Judge A Le Grange. You mentioned, as you were going through your plan, that it or aspects of it have the support of your colleagues.
Yes, Chief Justice.
Mm-hmm. Does that include the acting judge president?
Yes, because what has happened is we've discussed it, and we have an open discussion in terms of how we should do things. And she is aware that we have different views and opinions on certain issues.
All right. Just to round off on your CV, you've also acted in the competition courts?
Yes, but that didn't materialize as I would want it to be, because what happened is that there were no cases. And then I got appointed as acting DGP. Then I phoned JP and said to him, I think I'd rather concentrate on the work that was given to me, and that was the end of it.
All right. And whilst the magistrate, you were the national executive president of JOASA.
That's correct.
Which is an association of magistrates.
That's correct, Chief Justice.
For a term.
I was for 2 years. It's a non-renewable term of 2 years. And I can proudly say that I and the chair of the gender desk, or one of the magistrates, discussed the gender desk in the organization when I was president, to promote the interest of the female magistracy. Because at that time, in 2000, there was very few black female magistrates in leadership. In fact, I don't think there was. So we've worked on it, and I can say that the first chair of that gender desk is now a senior member at the Supreme Court of Appeal.
All right. That's something to be proud of. Okay. Judge Gamble, do you have any questions for the candidate?
Yes, thank you, Chief Justice. Judge A Le Grange, sitting where I am in the, I suppose, the departure lounge of judicial officer, I'm very encouraged by your visions. It's good to hear that there's a plan in place. I've got just 3 issues that I'd like to raise with you. The first is the question of the criminal backlog. And the commissioners this morning had questions for Judge Goliath in that regard. The backlog is extensive, and you've spoken about bringing it down. One of the problems, as I understand it, is that effectively the judge president has no control over the amount of criminal matters coming in. That's the prerogative of the DPP. You get told that the following cases are on the roll for the following term, and please find us judges for it. How do you address that problem?
Well, we did address it in a practice directive. So what we said to the NPA is, whilst the matter is still down in the lower court, and before transferring it to the High Court, I want a practice note from the NPA to tell me exactly what's the nature of the case, how many accused are involved, what's the complexity in terms of the indictments that we're dealing with, and the time period that they think this matter will run. So we've changed our practice directives to deal with that issue. So before the NPA can transfer a matter, I first see what it is, because what has transpired in the past is the DPP just transfer matters to the High Court, to what we call a pre-trial court. And then you will see a host of matters sitting there, and we don't have the judges. So before a matter gets transferred, I know beforehand how long that matter is going to run, how many state witnesses they intend calling, and how many of the accused might call witnesses, etc., so we can plan properly. I mean, I can tell this commission there is now one case that's still in the district court, in the lower courts. Highly complicated organized crime matter, where it is alleged that the construction mafia is involved. And there's also an ex-high politician involved in that particular case. We track that matter, because when that matter comes to the High Court, that matter will be allocated to a person that can deal with it accordingly and have a quicker turnaround time.
My second question relates to serving the province. Our province is huge. It runs from Vredendal in the north, Cape Town, Beaufort West, Swellendam, and right up to Plettenberg Bay in the east. As you know, I'm a keen one for circuits, and I regularly do circuits because I believe that's the way that you take justice into the community. It does seem to me from the way things are going, that there is an ever-increasing necessity for a local division to be established in perhaps George or Mossel Bay. Probably George, because George has a bigger commercial centre. That would enable the division to cover Oudtshoorn, Plet, Knysna, Mossel Bay, Riversdale, even down to Swellendam. And it would make it easier for civil litigants to get to court in a place like that rather than in having to come to Cape Town. Have you any thoughts in that regard?
I know that I think it was the Moseneki, I'm just trying to think of the name, that compiled a report with regard to the court structure. So there is the suggestion that George be a local division, a permanent local division, and I support that wholeheartedly. But once again, these are budgetary constraints. Let me explain to the Commission the following. Because I'm dealing with circuits, if you send a judge on a circuit, you must determine the length of that circuit in terms of time period. Because it's not only the judge that's going, it's the judge, the secretary, the stenographer, and the interpreter. Because OCJ functions separate from DOJ. So, and then you must take into account the prosecution and the legal aid. Because all of them are coming from Cape Town sometimes, and the cost involved. Because to put up all those people for a period of 4 months, 5 months, drains the budget. So when that has happened, for me, it is, what's the case that we're going to deal with, and will that case be finalized? So when a circuit is being declared by me, I know that this case will be capable of being finalized within that period of time. And I think that is an important factor when dealing with circuits. We've got a continuous civil circuit within George that's running for a term. 2 weeks the first portion of the term, and 3 weeks the last portion of the term. But once again, it is the cost implications, because our budget has been cut. And there is just a problem in that regard. But we go out as far as possible on circuits. I myself, as acting Deputy Judge President, has gone on circuits. Because I know for the fact this case will take 2 weeks, and I finalize it within 2 weeks. Within my period as acting Deputy Judge President, I finalized about 6 cases in the last months from the start of this year. So I'm going to court and deal with it. I've also, in order to avoid this paper war that we're fighting, at one instance I assigned myself a matter, a review matter, and the paper was this high. And I phoned Justice Muslam and I said, look, it appears that these attorneys all are on your platform, on case lines. Can I jump on your platform? And his reply was, well, it's for all of us. Luckily, a day before the matter had to be heard, I was phoned that the matter has been settled by the parties. But that is the innovation that we need to do in order to get things going.
The third is a remark, perhaps on a lighter note, because I know you have great difficulty with control over the building. But if you do get the job, could you please fix the toilets on the 2nd floor that are used by judges? Thank you, CJ.
Thank you, Judge Campbell. Mr. Boshoff?
Thank you, CJ, and afternoon. I don't know, ADGJP sounds a bit silly, but yes. Just two brief questions. I think the one is a follow-up on Judge Gamble's question regarding the circuits, but there was a comment from one of the submitting bodies, I think the National Bar Council, and I think I'll just repeat what they asked, but how you would or could potentially use technology in a similar way, or the innovation that you've shown with your criminal initiatives to potentially, we're talking about circuits now far away, but there's a need for access and easier access to justice on our doorstep in the very poor communities around Cape Town, Kailicha, Langa, Elsie's, so is that possible? And I know budget and everything, but being in government myself also, you have to make do with an ever constraining fiscal space, but that's no ointment to the wounds to people who are sitting there desperate for, if they have to decide between, well, the transport to court is going to, be the difference between a meal tonight, then, that's not justice. So I would just, and then there's a short question after, but I think I'll give you an opportunity first to answer that.
I think we have to embrace technology and use it to advantage. Whilst we were discussing with the regional court president some of the difficulties that she experienced, one of the options was to, instead of a magistrate that had a parted matter in Bellville, but she was appointed in Vredenburg. So they put up in front of a laptop there in Vredenburg, and then was hearing the matter, the rest of the evidence in Bellville, because he was working there in Bellville during an acting period and pick up it. Now that's the innovation. So it saves cost. And I fully agree that we must embrace it. But it is sometimes problematic because the speed of the Wi-Fi might be a problem. Then pictures get frozen and everybody becomes unnerved about it. So it is those infrastructural problems that we're facing. But I fully agree with Mr. Bossel that we need to embrace technology. And insofar in terms even postponements in prisons. As far as I'm concerned, and I'm not too sure how many have ever experienced Cape Town M3 on the morning, with all these vans chasing down those things, is to have a postponement whilst those that we know we're not going to deal with. But what we do find now, there is objection to that from the accused, because they want to come to court. They want to see some of the families. But there's also other reasons why they want to be there. So those are issues that we are dealing with, that we would like to engage the NPA with. And if I get recommended to Judge President, those are the innovations that I will drive to ensure that there are cost-saving measures in place, in particular in that regard.
Thank you, Judge. And then the second one is you would have seen there was an objection from a Miss Albush that was filed. Now, I mean, what I really just want to ask, it seems it was somebody who appeared in person. There was an earlier appearance before AJP Goliath, and the matter was, well, at that point it was DJP Goliath. I don't know. I don't know the details of it all. It involved an eviction and etc. Then this person appeared before you in court, and in your response you filed the transcript of the proceedings, and the person was unrepresented, and I think if I go by the transcript, the proceedings lasted all of a minute. And you had dismissed the matter for lack of urgency, and you advised that they rather approach the Madge Court to have it rescinded, the order that they took issue with. My question isn't so much about the matter, but more about the perception that an unrepresented litigant appears before you, and the transcript creates an impression of a bit of a potentially, I suppose, without being unfair, and please understand it's a question, I'm not accusing, but it comes across as quite dismissive, especially when somebody's unrepresented. So I would just like to hear your comments on that.
Thank you, Mr. Commissioner Boshoff. Firstly, I've got no independent recollection of this particular matter. I asked my secretary to see if they can draw a file that period, and when the file arrived, my response is accordingly that. Ordinarily, what would happen is that if there is a person or litigant that appear in person, and you're on urgent duty, you will get the file before and go through it. And then you go to court and deal with it accordingly. So I cannot, it might come across as sort of dismissive, but that's not my way of dealing with matters. If that was my way of dealing matters, Commissioner Boshoff, I can tell you now, Advocate for Transformation would not have recommended me or supported me. Neither the 3 female senior counsel would not have put their signatures to recommend me. That's not me.
Thank you, CJ.
Thank you, Mr. Boshoff. Commissioner Gotsa?
Thank you, CJ. I was covered by Mr. Boshoff in part about the remand detainees and the use of AVR. I was also recently at Polsmoor, and I've seen exactly what you've seen, and I'm just interested in, could you maybe just briefly expand on how you will work with the lower courts and the regional court to make use of those facilities in order to deal with the issue of remand detainees faster?
If recommended as Judge President, I will issue a directive in that regard in terms of the postponements, how we can deal with that. But before issuing a directive, I will sit down with all the stakeholders and see how we can deal with it in a more efficient and effective way without transporting all of those people all the time. But there's limitations to all of this, and it's progress. It will be over medium to long-term period to implement it. But it is there and we need to use it. That court was never optimally used. It was always there. But since I took over, it's now being optimally used. It's every term there's a matter down to be dealt with. And may I add is that one of the judges that's sitting there is one of the more experienced regional court magistrates, and she's a female that's dealing effectively in that particular case, in that particular court.
Thank you. And then just to confirm that in Cape Town, we have 2 types of blue light brigades. The one being the one from Polsmoor.
Yeah,
Commissioner Marumachai?
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Initially, I wanted to speak to you about your judgment, Musa versus Heneka, that was confirmed by the Constitutional Court. But you said something in your vision that really required me to actually focus on those because I thought they were important. The first issue that I want to address you on, or to ask you on, it is the issue of, which is part of your vision, that you want to interact with stakeholders to see how black lawyers can be made part of the system so that they can survive. I think in most instances, the issue of briefing and all the issues that we always talk about in terms of how other people get access to work, it comes across as if we need to do black people a favor, that they need to be made part of. And we end up making the white person who's actually is being paired with a black person to look good. Like, I've done this for this person, I've done that for that person, and I have an issue with that. What are the more nuanced and strategic sort of suggestions do you have should you be successful, even if you don't become successful, that can actually assist within the context of the Western Cape to ensure that the people that you refer to as disenfranchised are actually being made part of the briefing patterns? Business changes its mind, government changes its mind, and when they are paired with wide senior account, they are actually relied on because it's about opportunity. It's not necessarily about people being paid for their fees and all that. It's about getting opportunities and proving yourself so that people can realize that you are good at what you're doing? What are the sort of realizable sort of goals do you have or objectives that you think can be achieved to change this, the mindset in terms of changing the briefing patterns?
Commissioner, it's a very difficult question, but one can do something about it. As Judge President, you have to have, as I indicated earlier, your finger on the pulse in terms of what's happening within the profession at large. And one of the things that I'm currently doing is to get involved with training at the bar. I do moot court during recess periods, in particular for pupils that's at the bar. But there is it's an issue that we need to talk about networking as well. It's how do we, that has been previously disenfranchised, network ourselves in terms of showing that we are capable of doing it. Because you cannot just sit and think that somebody's going to knock on your door at your chambers and say, sorry man, are you doing X, Y, and Z? Come appear for me. We need that, and we need to tell our young practitioners that we need to get involved with the organizations. We need to get involved and be more active in that regard. So it's not a case of, yes, a white man, I must now be paired with him and then transfer skills. But it is, how do we also ourselves work the system in terms of showing up, in terms of going out there and tell the people that I can do this. I'm capable of doing it. Give me the opportunity. And I think that is where the involvement of BLA, NADEL, Advocates for Transformation, plays such a fundamental role in that process. I hope I've answered you.
Yeah, no, I appreciate the answer, but there is the issue of touting as well. That might complicate the situation.
Yes,
But
that's what I'm
nonetheless,
saying.
let me go to my second question. Should you be successful, you will be leading a division that will obviously and invariably hear political disputes that often have the character of legal something, and you have to deal with those. And there is a sense in the country that, yes, we talk about separation of powers, and we try to explain it, and we try to even teach it in universities. But it appears in reality that there is some level of judicial activism in South Africa, which potentially can turn the country into a judiciocracy. What is your view with regards to that?
Commissioner, remember Parliament sits within our jurisdiction. So obviously, if there are disputes of Parliament, it flows over to us in the Western Cape Division. With regard to that, it is, we don't ask for matters to come to the High Court. It is when there's a fallout and a dispute, then it ends up at the High Court. But the question in terms of the Western Cape itself, it is, this is the bench. And we have to allocate these matters.
I will leave it there, CJ, because I raised the issue of judicial activism and judiciocracy, but I think I will leave it there.
Thank you, Prof. Commissioner Breitenbach.
Thank you, Chief Justice. Good afternoon, Judge
Good
A Le Grange.
afternoon, Commissioner.
If you are successful, you're going to go back to a division that is, in my view, seriously fractured, with many divisions and many problems. Why do you think you can heal those fractures in that bench. And while you're answering that, could you tell me what you think the one most important attribute of a judge is?
Can I start with the last question first? Integrity. That's our currency.
Thanks.
Without integrity, that's the core of what judgeship is all about. Honesty, openness, transparency. If a litigant walks into a court, despite that he or she would accept that the person knows and understands the law to resolve the dispute, is to know that this person with integrity will deal with my matter. That is, for me, it's non-negotiable. With regard to your first question, Commissioner, yes, there are fences to be mended. Yes, there are different views and opinion, but there's also an enormous amount of goodwill. I've been in that division, as you all know probably now, for more than 17 years. I've seen that division grow. When I started, it only had 27 judges. It's got now 33 judges. In fact, it needs more. But most of the judges, apart from 5, were appointed after me. If the judges that's going to leave soon, the next 18 months, I'll be in the top 3 in terms of years of experience. I understand the complexities, the dynamics. I understand the individual judges in terms of their personalities. So from that perspective, I will have a deep sense of what it is that might be the reason for whatever differences there might be. And that is why I feel that we need to heal ourselves from inside so that we can contextualize what has happened within that division and have an honest and open and frank talk, which we never had. We never had a session of sitting down and just talking to one another. I think when Justice Malambo was there at one Friday afternoon, it was the first time where a majority of judges were together because case lines are so important. And the laughter, the bantering, it was so good to see that within that division and environment. And it can happen. It needs leadership to do it. And that is what's the position. The reason why we haven't done the talk yet, because there was a view that in this transitional period, let's wait for the judge president to be appointed so we can deal with this in that fashion.
Commissioner JP Malambo.
Thank you very much, Chief Justice. Good afternoon, ADJP.
Good afternoon, Judge JP.
One thing that makes a bench gel, when I say gel, it's like function optimally, is when it is collegiate. You understand what I'm trying to say? When you have a collegiate bench. I see you're not responding.
Oh, sorry, I'm watching you here, so on the TV, because you're so far away, so I'm watching here on the screen.
So I want to understand whether you understand what I mean by a collegiate bench.
My understanding of a collegiate bench is a bench that is collegial with one another, that is understanding the issues and understand what needs to be done, unless I've got it wrong.
And they can work with each other.
Yes, of course.
Am I understanding you to be saying that's not the case as we speak in the Western Cape?
Judge President, I tend to differ slightly. Colleagues are working together.
Yes.
Colleagues are dealing with matters as we sit here, and colleagues are sitting in full bench appeals, in applications. They are working together. There might be colleagues that has got different views and approaches to certain things, but as a division currently, we are working and we are doing what is required. On that score, let me just go a bit further than that. You must remember that the fallout between two leaders affected us tremendously. It didn't only affect us, it also affected the support staff. And we need to build on that. Whoever takes over as Judge President need to understand what really transpired within that division. I, for the first time, when it was Secretary's Day last year, said, the secretaries, we're going to have a function for them. There were some issues about there's no money or whatever. I said, I don't care. We're going to have a Secretary's Day. Because those are the people in the support staff that also got affected by it. We got a Secretary's Day. We had a finger lunch. We bought small little presents for them. Just to say thank you. Thank you for the support. Thank you for being there all the time. And they really appreciated that gesture coming from the judges. So, yes, we are working together, but, you know, there are always differences with judges. You know, some people support guys, and I don't want to make light of it, but we banter with each other in terms of who's winning and who's losing, etc. But the serious differences in terms of what's there need to be unpacked. Because remember, commissioners, names were mentioned within the complaints of judges. And some of them feel offended about it. Some of them feel that, you know, why I got dragged into this mess now? What did I do wrong? And we haven't talked about it yet. So those are the core issues that we need to deal with.
Okay, so what you're saying is that colleagues are working, but more needs to be done to bring it together to be a bench that functions optimally, that understands what it has to do. That's what you say.
I agree with that summary, JP.
Okay, thank you very much for that. Now, my second question is, you and AJP mentioned backlogs. You know, I get worried as head of court when I hear that there are judges who are carrying 3, sometimes more than that, in terms of part heads. You worked in the regional court. I don't know whether you've had occasion to chair a PEEC.
Yes, no,
Have you chaired a PEEC?
I know what you're talking about.
You know what I'm talking about.
Yes.
But the question is, the reason the regional court has a problem is they don't have a continuous roll system.
Right.
At any given point in time, you find magistrates at some stage carrying something like 25 part heads, one person.
Yes.
Now, looks like the Western Cape Division is going there.
No.
That's what we had.
No. Let me explain that, JP.
Yeah.
Before I arrived to deal with the criminal division, there was a project that the previous judge president was dealing with criminal matters. He got a few judges, 4 or 5 of them together, that only did criminal work. So what will happen is that the NPA will, you start with a matter, apparently, that is what I've been told, and I stopped that. You start with a matter. So when there's a delay or there's somebody got sick or they can't continue with one matter, they will bring another matter in, like in the regional court. Because these judges are now going to just do criminal work all the time. But the difficulty with that is the bulk of those 4 or 5 judges are acting judges. And when I arrived and I realized what was happening, you know, those matters were already there as parted matters. So those are the things that I stopped and said, It cannot continue like this. You start a case and you finish a matter. So that perception that we might go to the regional court, not under my watch. But
So
we've got it now. We've got it now. It's old cases that's...
Yeah, am I
that's-
understanding you to be saying you embrace the continuous role system?
Yes, no, of course, absolutely.
I see. CJ, can I ask one last question?
Yes, JP?
We put some questions to the AJP, and I'll put it to you because you're part of the leadership as we speak. And this was raised in Judge Ali's memo of allocation of sometimes of complex matters to acting judges. I gave the example of one matter, very involved refugee immigration-related matter. That was done by an acting judge. And I asked myself, how does that happen when there's a leadership that must check what's on the roll and check who must deal with it?
Judge President, I've got specific duties that was given to me by the acting Judge President. And one of it, I allocate 2 days of the week, on a Monday and a Friday. I go through the file before allocation. And in fact, it is not uncommon that I will phone the judge first. It happened, I mean, that certain, but not under my watch. And we're not saying, try to blame the AJP here. I mean, she might have had her own reasons. But you must understand that there are acting judges that's coming from the magistracy. There are acting judges that comes from the attorney's profession, and there are acting judges that comes from the bar.
Can I stop you there?
Yes.
I want to hear you tell me how you as a leadership, or if you get the job, how you will address that.
I will address it immediately in terms of, and you must screen the matters, and also in terms of going online, because you must be able to understand the strength of your bench. And the way I will change that is to do the allocations. And I will be able to understand exactly what case is going where once we have our system up and going. And it's a simple system. It's an Excel spreadsheet with all the judges' names on, with the dates. You can see there is case X going to Judge Y. When you pick it up, you can see, but hang on, you know, this is an acting judge. This is a rather weighty matter. So those are the things that I will immediately implement.
Thank you, CJ. No further questions.
President Mulemer.
Thank you very much. Good afternoon, my brother ADJP.
Good afternoon.
I think I must just preface my question by saying, please don't take it in a pejorative sense. I'm just trying to understand something because my understanding is that you have been ADJP for over a year.
Yes.
Am I correct?
Yes.
So you and AJP Goliath, I assume, have been working as a team.
Yes.
And if you were working as a team, you probably had a shared vision about where you want to take the division.
With regard to the shared vision, you must remember that when we discuss issues, there might be some different view and approach. And as AJP, she's got the final say. So if I propose a particular route perhaps, and there's a different view on it, well, her decision stands.
Yes, so are you suggesting that in relation to some of the things that you say were your initiative, like postponement of matters at correctional facilities and so forth, the ones that you managed to get right, she was amenable, and the ones that you say you are still going to do are in respect of matters where she was not amenable?
No, I'm not saying that.
Yes.
What I'm saying is that this is ongoing in terms of the role and the backlog. It is trying to deal with it in a more efficient and effective way. Because, see, left the criminal division in my hands. And I dealt with it in that way. I'm not saying that she didn't approve of it, no. Or that's not her vision at all. I hope I make myself clear.
I hear you. So the flaws or the weaknesses that are in the system are there despite your interventions in relation to the criminal matters, because you say she left them in your hand. So meaning what you are still to introduce is something that you could have introduced before because she left it in your hand.
President Mulder, the issue here is you must remember that we're working with a whole range of factors. It is not just a matter of implementation. It is a matter of getting the stakeholders together with a period of time. And we discussed the issue of, I think it's AVR, with the DPP. But it is a time factor and also a resource factor. There is, the problems that's there is a holistic problem. It's not a problem that's saying you can rectify it overnight or you can rectify it within a month or so. There are all sorts of role players that needs to be involved in that.
Yes. My last question, CJ, with your permission. I'm asking all of these questions in order to try and fairly assess or gauge whether you would be able to implement what you have set out in your vision. That's why I'm asking all these questions. One item that you said is what you can do in the short term is in relation to allocations, and I think when you elaborated on it, you said so that, I'm paraphrasing now, so that allocations must be seen to be done fairly such that no one feels to be overworked and someone is seen walking around the passages as if they don't have work. So my question is, why have you not been able to intervene in as far as that is concerned as part of the leadership, as the person who has been part of the leadership for more than a year?
Well, that is where the difference of approach and views comes in.
Excuse me, sorry. I didn't get that.
That is where the different views come in and
Oh, I
approach.
see. Oh. Thank you, CJ. Thank you, ADJP.
I'm sitting here listening to you, Judge Le Grange, and I just get a feeling, it's just a feeling that you are tiptoeing around issues. You're not coming out clearly, being fully candid about what's going on, and but I'll leave it at that. Commissioner Nkonyan?
Good afternoon, CJ and Commissioners. Good afternoon, Judge Le Grange. I'm here.
Sorry. Oh, sorry. I'm just looking at.
I'm here. Thank you very much for your responses. There's one issue that I would like you to clarify us on. At the present moment, the AJP is the head of court, and DJP, you are the assistant. Assuming you succeed, becoming the head, and she naturally referred to her position. In view of what has been happening in that provision around the issue of unity and cohesion, how is that going to happen? Will that collegiality that we have been asked about before continue or to regress? I just want you to comment around that issue. That's the only question I have.
Thank you, Commissioner. It is not a secret that the AJP will always say, and she mentioned it in the tea room as well in front of other judges, that I've got calm demeanor and a way of dealing with issues on an even-handed manner. And she made it known that she will work with me. But over and above that, you start to learn to know a person if you start working with him. And I just want to address the point what the Chief Justice said, I'm trying to tiptoe around issues. I'm not trying to tiptoe. If that is the impression, then I would like to correct that. In terms of the allocation, it's an issue that has been raised. But it's an issue that, at that point in time, the AJP feels uncomfortable to implement. Why? She's the AJP and she made a decision on that. Because what's happened currently is this. The secretaries come with the allocation notes. They give, write on a piece of paper, they say my judge is available on this and this date. These are the matters. They take the secretary's note up to a pigeonhole. Then somebody corrects it from there. Write it manually into allocation lists. So then you will have a list where you have to allocate matters from. So you look at dates. You've got a matter, you sit with the matter here now. It's for 2 weeks from now. Now you're looking, whose judge is now available 2 weeks from now to allocate the matter. But we don't know what happened in the interim period with a judge that's from a day or two ago, the availability. So in order to avoid that, because now you allocate the matter, the file goes down to the judge phones up and says, but listen here, don't you know that I'm busy on such and such a date? I can't deal with this matter now. Now, how do you address that? It's simple. You put an Excel sheet, you put it on computer, there is the OneDrive system. So when you do all your allocations, within seconds, somebody else can open up their laptops. It's there. They can see it. So it will avoid all of this tension that might be there, or the issue of preferential treatment.
You're doing it again, tension that might be there. Is there tension or is there no tension? Which is it? I can actually feel your pain as you're trying to count your words, and it's so painful to listen to.
CJ, what I'm just saying is that, obviously, if I get a file and it appears that I'm busy, then there is a sense that, don't these people know what they're doing?
Okay.
That's the point I was trying to say. It's that you are allocating matters, but don't you know that I'm busy with another matter? That is essentially what I'm trying to get across.
Yes, Commissioner.
I became confused. In the course of the Honorable Justice answering me, he then came to explain the tiptoeing. And in my mind, he was really tiptoeing around my question. Can it be clear to what I was asking?
Go ahead and put your answer, your question again, if need be. I'm sorry for...
Okay. Thank you, Chief Justice. Judge A Le Grange, I was asking you that assuming you are successful and your boss become your immediate subordinate, that is acting judge president, becoming revert to her position as the DJP of that province. In view of what is publicly known, and in view of the stance that I have no doubt you and her have taken to improve the unity and cohesion within that division, I was asking you, will that not affect that if you now change the roles, you become her boss and she becomes your junior, as it were?
Commissioner, the answer to that is no, because she indicated on more than one occasion that she is willing and prepared to work with me as DJP.
Thank you, Mr. Chair.
Commissioner Ngaiton?
Thank you, Chief Justice. Good afternoon, Judge A Le Grange.
Good afternoon,
Yes,
Katobi.
look, just to place it on the record that I've appeared before you several times, and I've never got any sense that you don't know what you are doing. It's always been a pleasure. But I've got a problem with the way you've answered the question around Mrs. Albers, who was not represented. I know that you say advocates have praised you in your manner in court. I could join that list as well. I think your manner in court is very good, but I always, when you read something like Albers, well, is it because I'm an advocate? How does he engage with the unrepresented? Now, I've looked at the transcript of that hearing day. It starts at 9:53, it's over by 9:54. And it starts by you saying, are you the one who was evicted? And then she says, yes. And then you say, well, I'm not going to deal with this matter. I'm going to remove it. She says, well, no, but the magistrate didn't do a proper job. You say, well, let's go back to the magistrate's court and do a rescission. And then she tries to speak again, and then you interject and you say, matter is removed. Now, given the context of that case, that it is an eviction case, Cape Town is notorious for evicting of poor people from housing. Section 26 is a constitutionally enshrined right. It seems that the way you dealt with that case showed a level of impatience because she's not an advocate, she's an unrepresented person, and she's being roughed up by the judicial system. So I do want to get a better answer from you, because I don't think you get the gist of the concern.
Commissioner Katobi, I fully understand the question that you raised. And if one look coldly, that impression might be created. But as I indicated to the Chief Justice and the Commissioners before, I've got no independent recollection of this particular case. But that is not my style of working with unrepresented litigants. And if that is the way I operate, I can tell you now that there would have been a complaint about it. If one, and the reason why I refer to the advocates is if you have regard to the comments from the General Counsel of the Bar,
No, I don't have a problem with the GCB. I accept fully. I've got a particular problem with the way you appear to have roughed up an unrepresented litigant on an eviction case about a home.
but as I said, on the cold facts, it might have looked like that, but that is not the way I deal with matters. And I will accept your criticism on that.
Then can we move on to another aspect, which also I've got a problem with, and I do need to get some explanation on. The issue about your involvement in leadership, about a year having been an acting deputy judge president, I understand all of that. You've presented a vision that places you as an outsider, but in reality you are an insider. There are 4 issues, well there are many issues, but let's pick 4 from Judge A Le that she is protesting about. Number 1 is the issue of the abandonment of the continuous role. We asked the candidate before you, the acting judge president. She explained why she's not using the continuous role. Your answer is you want the continuous role to be used. You support it. Number 2, Judge A Le complains about arbitrary allocations, where there is lack of transparency about why allocations are given to certain judges and not to other judges, and which has also caused resentment because permanent judges are being overlooked for very serious and important cases in favor of acting judges. Number 3, minutes are not being kept, so you end up not knowing what was decided. The acting judge president has defended herself on that, about why minutes were not being kept, the matter coming all the way from 2010. And then number 4, it's the lack of consultation and lack of joint decision making. Now, we put all of those to the acting judge president, but I think that we should also put them to you, because you are also the acting deputy judge president. You're not an outsider, you're an insider. If these are true for Judge Goliath, they must be true for you. So could you just explain, firstly, whether you think the criticism by Judge A Le is correct or fair? And if you think it is fair, why you have done nothing about it for more than a year?
With regard to question 1, in terms of the abandonment of the continuous role, there are judges that's doing criminal matters that has been ongoing for some years. In fact, there's one matter that's going on for 4 years, and the state has not even closed its case. That judge was an acting judge when he started with the matter. He's now a permanent judge. And he, on more than one occasion, came to me. I'm not too sure if he went to the AJP, but he came to me and said, Judge, please, I need some civil work. So what I have done is, when I allocate on a Friday, and there's a civil matter, because we allowed him to deal with that matter, because it's a matter that's going on for some time, for the entire period, because ordinarily Fridays are appeal days. If he can do on a Friday a civil matter. So from that perspective, there is then an interruption, because the judge's been sitting for so long just doing criminal work. And he wants to get exposure with civil matters. And he's a relatively young judge in terms of years of appointment. So with regard to the abandonment of the, or let me put it, the criticism from Judge A Le, if one have regard to that, that was discussed in a meeting. And I said to the meeting there, because of judges that are in civil pool, because this is one of the judges that came to me and talked to me about it. He says, listen, I've been sitting in so long in a criminal matter, I want to do a civil case. That because of that, we will allocate civil matters to the judges. And it's not as if you break the entire continuous role. It's an application, a one-day matter. It's not like the person is now have to do a civil trial for 4 or 5 days, and then the matter stands over. And it does happen within criminal matters sometimes, that the matter doesn't run for a variety of reasons. Somebody got sick, witness doesn't pitch, etc. And it's in that periods then that these matters can be heard. So that is how I see it from that perspective in terms of the continuous role. But we cannot function without a continuous role. I don't know what the AJP has told this commission, but we need a continuous role as far as possible. Because you can ask any senior judge or judge president, it will cause chaos.
Yes, Judge Le Grange, you know, the real issue I'm trying to get to, it's very unusual for this body to receive an objection from a sitting judge against another judge. It's the attorneys, it's the advocates, it's the clients. But to get something from a judge that says this person is not fit to become a JP is a big thing. So that's why I'm saying we've been debating with the person accused of all of these things. But it occurs to me that we should not let you off the hook because you are an insider. And the reality is, I'm trying to get to whether you think, so it must have taken something very seriously for Judge Ali to come to the point where she's sounding an alarm to the whole country about the state of the division. You are a leader in the division. These things should have been raised internally or maybe were raised internally. The real issue is why have you, as the acting deputy judge president, forget about Judge Goliath, her interview is over. Why have you not done anything to address the problems of one of your colleagues?
Let me answer it this way. This complaint, I haven't seen it. And I haven't seen what exactly Judge Ali was raising with the AJP. But I know for a fact that the issue of the continuous role was discussed in a meeting, and that's how we dealt with it. In fact, it's during that same meeting that Judge Ali was indicated that she's prepared to do a judgment writing seminar for an hour or two for the acting judges. And she did it. I was present when she did that judgment writing workshop with the acting judges.
And minutes not being kept?
The minutes that has been kept, it's a long issue that's coming on for some time. And the AJP has decided that minutes are not going to be kept, and that she made a ruling on it.
And the arbitrary system of allocation where there is no transparent system?
As I indicated to the Commission at large, if we introduce a computerized system, that will fall away.
I understand that, but I'm asking you to account why you've done nothing for a year because you've been in the leadership.
Commission Katobi, that is where the different approaches arises. Where you say, fine, look, we need to change this. We cannot continue using the system. It's an old system.
No, I get that. And then the last of the four complaints, which is the lack of cohesion, consultation, collegiality, working together in the division. You say that's, well, let me not speak for you, but give you a chance to explain yourself.
I want to say the following, and that is, that's a process that we need to deal with. Colleagues go about their work. We are dealing with our work, and there are interaction. The cohesion that there is, or the differences, we must have more often meetings. Currently, we only have one meeting a term. That is...
No, sorry to interrupt. It's really about why you've done nothing about that issue since you were at DJP.
In terms of cohesion of getting the colleagues together.
Yes, the plans you're outlining, which I must confess I agree with, but if you are an insider, you must also account about the time you were there and you did nothing about the things you are promising.
What I can say is that you have to understand that within the division, we've had the occasion of having a farewell for one of our colleagues that retired. All of the judges attended that, his retirement. We had an occasion where we thanked the acting judges that came at the end of the term. The judges were there. And we have our functions now and then, and the judges attend to. That is part of the process.
Thank you, Chief Justice. Thank you, Judge A Le Grange.
Thank
There's
you.
a follow-up question, Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Judge A Le Grange.
Good afternoon, Commissioner.
Judge, there's been a common theme throughout your interview, and I'm a bit concerned that you seem to be dodging the issue rather than deal with it head on. So I want to give you a further opportunity, probably your last opportunity, just to deal with the elephant in the room. I think what we're trying to probe, Judge, is the extent to which, in your capacity as a DJP, you were able to exert influence in order to address all of the challenges that we've heard about throughout the course of the morning.
In terms of me addressing these issues, I have, as I said previously, the fallout didn't only affect us as judges, it also affected the staff. And I was firm about it. Let's get the secretaries together on Secretary's Day. With regard to getting judges together, we've got a functional tea room. And we are having that, and we're trying to arrange, or not try, we did arrange some get-togethers. Now, it's very difficult if judges say, well, I'm not going to come to this function, because you don't know what's the reason for that. It might be, he or she might be busy. There are all sorts of other reasons with it. But as Judge President, and I think this is where the Commission must understand, is that we did not have a talk and a discussion together.
Sorry, please just clarify, when you say we didn't have a talk together, you're saying you and who?
No, as a collective. As judges sitting down and say, look, we need to move on and we need to address, as you put it, the elephant in the room. What causes, what is it that you might feel offended that I did or I say as Judge A Le Grange, or what is it that someone else might feel offended about? And the Commission might think I'm tiptoeing around it, but it's not. It is a fact of, and I think that the Commission must understand, it's not just a matter of walking to a person's chamber and say, listen, why don't you, what's happening here? Why are you doing ABC or whatever the case may be? I haven't seen you for a while. Why are you so quiet? I chat to judges, and I walk sometimes to their chambers, but it is not the way to deal with it. I think
what is the way to deal with it?
The way to deal with it is to get together in a room like this and to talk about it. Because as I said, CJ, before, the fallout has caused and affected people differently. And we need to debate and talk about it. We cannot just assume these things.
And Judge, why hasn't that happened yet? You're the ADJP, you're saying this is such a necessary event to take place. Why hasn't it happened?
Because of the interim process, because the reason why it's not being happened is there was a decision taken that wait for the JP to be appointed to deal with this. You must remember also there was also the case pending from the previous JP still in terms of challenging a lot of things in higher courts.
Okay. Commissioner Moimang? You are covered.
Thank you.
Are you covered? Okay, no, you'll get your turn. Commissioner Moimang?
Thank you, CJ. Introduce yourself, Acting Judge, Deputy President, the side.
Oh, yeah.
On your right.
Thank you. Just two questions from my side. The first question is whether are judges allowed to protest?
No.
Because of your protest against sitting on an appeal matter, which to me put into question the issues around the commitment, around judicial temperament, commitment to public service. I think the first question that comes to my mind, what was the impact of that protest action on the affected parties, and the extent to which that protest action delayed justice to be discharged. The second one relates to the point that you raised to say, and repeatedly have said so, that because of different views with the judge, with the acting judge president, this did not happen. So the only question that I want to ask is, upon your assumption of an acting position, because I believe that you are the most fortunate one to have acted for that period. Like now you are still acting, meaning that there was confidence in you displayed by the acting judge president. Now, in terms of key programmatic areas, obviously around strategic level in terms of moving the Western Cape Division forward, emanating from the quagmire that it was facing. Do you want to tell me that we never had a strategic session with the acting judge president to isolate these issues and agree on a common approach to say this is what we are taking to your fellow judges? Thank you, Chief Justice.
Thank you, Commissioner. In terms of the first question, the protest action, I don't see it as a protest action in that sense. I see it in a way of protecting litigants that appears before a court of law that expect judges to behave in a certain manner. Open, transparent, and integrity. And if one have regard to some of the case law, although not on point, it's quite clear that judges can decide not to sit with other judges. But those circumstances are rare, and this one is one of those rare circumstances. The second issue in terms of strategy and of the way forward. The first thing that I said is that we must have a judges' meeting. And I don't know if the AGP indicated that for the first period she acted on her own. But she wanted to show that she can run the division. And that's her decision, because ultimately she is the acting judge president. Now, the strategy of how are we going to deal with the issues at hand? As I indicated previously, I'm not trying to tiptoe about it. The decision was taken in terms of the interim phase of the leaders to postpone that until a permanent JP has been appointed. And that is it, Commissioner.
Sorry,
Follow-up, CJ.
whose decision was it to suspend fixing things until a permanent JP is appointed? When there are people, two people acting and being paid the same amount a permanent JP and a permanent DJP, well, there is one, would be paid to execute these duties for which you are appointed. Who took that decision to suspend the well-being of the division?
Well, Chief Justice, we had a discussion about it.
Who? The entire body of
No,
the
no, no, no,
judges
just
there?
the two of us.
Oh,
Just the two of us. And that was the decision taken.
to leave the court in limbo while you were being paid to be JP
No,
and
no, but,
DJP?
sorry to interrupt, Chief Justice.
Yes.
My humble apologies.
Please interrupt because I want to understand.
It is not about leaving the court in limbo. It's about dealing with hardcore issues where the ADJP is also involved. It is about having someone to take charge and ultimately take charge of the division so that this can be discussed openly. And I think the motivation behind that was because obviously the JP had ambition to become the JP.
All right.
Follow-up, CJ.
Sorry,
Follow-up,
Justice, if I can make a follow-up.
Okay.
Look, this is
I've noted you.
I mean, on this quickly, this is what troubles me throughout. I mean, I share the same view by the President of the SA, the Chief Justice, and other constitutions. You were, yourself, you were handpicked by AGP Goliath. That is, she looked out of the 30 judges or 31. She recommends you to the minister to be appointed as an acting. Is that not so?
Yes, he came to me and asked me if I would work with her. That's correct, Commissioner Ntesi.
Yes. Now, having picked, meaning that you are a person, according to her, who fits into her own vision, into her own plan. You sat with her, where she presented to you, she tells you what she wants from you, how you should support. That is, you are engaging. First, you are handpicked. Secondly, she presents to you what is it that you are waiting for in respect of this judge president who was going to be appointed. What is it that you are waiting for?
No.
Because we are a team that has a mutual understanding. She picked you and we are comfortable to work. What was the problem?
I think Commissioner Ntesi must understand that there was certain duties assigned to me by her. Firstly. Secondly, I acted on those duties.
Yeah.
Thirdly, in terms of strategic discussions, we didn't go and strategic discuss in terms of things that we sit in a dark corner and chit-chat. No. It is about how can we stabilize the division? How can we bring and work together? And more importantly is the idea of getting together and talk about issues that is deep-seated issues
Yeah.
that caused, as a result of the fallout between the two leaders.
Yeah. No, it's fine. I mean, I think I will leave because of just a follow-up. But I just want to leave this comment. First, there is something that you are not telling us. It is something that you are not comfortable to tell us. Because in respect of positive things, well, we are prepared to say, that's fine, and then tell us. But insofar as there are other matters that we don't want to say, well, we are not a decision maker. And the third answer is that, no, you have postponed until a judge president is appointed.
Deputy Judge President, I just want to take you back to the question that was raised by Commissioner Muima, and I think that is where I got a feeling of unease. If I understand this, and correct me if I'm wrong, you were supposed to sit with a judge on a particular matter, and because of a moral call, based on what had transpired with the former judge president, and he said that, the other one said that, you took a moral call to say, look, but I cannot sit on this matter with this judge. Do I understand that correctly? Is that?
I think I might just help you. I didn't say I don't want to sit on the matter. I don't want to sit with a judge. The matter, because the litigants have got nothing to do with this. The file was immediately assigned to someone else, without even getting or given me an opportunity. Let me just place this in context for the commissioners, is that when I went to the judge involved, I said to him my dilemma. It's obvious that the judge then went to the previous JP. And then this file was just recalled from my chamber because I was the sitting judge, without giving me an opportunity to explain.
At the time, you had already taken a decision that you're not going to sit on the matter. In other words, now you are willing to explain why you are not going to sit on the matter. Like, do I understand correctly?
Well, I've expressed my view to the judge as to what I'm going to do. And I was also prepared to write a judgment on that.
All right, no, thank you very much, CJ.
Commissioner Le Grange?
Chief Justice, thank you so much. Good afternoon, Acting Judge President Le Grange.
Good afternoon.
Acting Deputy Judge President. I just want to take it from where Commissioner J.P. Mlambo has left it. He asked you a question about a collegiate bench, and you responded to it very succinctly. I see here there is a disclosure that you made to participate in an appeal matter with one of your former colleagues or one of your colleagues. and I don't want to go into the merits and demerits. Just to check with you if you think that your refusal to participate in that matter, with the reasons that you advanced, did it enhance collegiality within your division? And I think that in response to that question, you will also do it within the context that it was at the height of tensions and palpable divisions that were there in the Western Cape division of the High Court. Thank you so much.
Thank you, Commissioner. Commissioner, not one of my colleagues came to me afterwards and said that they had a problem with what I've done. In fact, I had the support of 10 other colleagues in this regard, from senior colleagues. Some of them retired, that were judge presidents in other division. Some colleague is now in the Apex Court.
Do you have another question, Commissioner?
No. I just want to check with you the manner in which you handled the matter, your decision to refuse to participate. Do you think that was the best option under the circumstances at the time?
Commissioner, let me say this in front of this body. Before taking that decision, it caused me sleepless nights, because it was not an easy decision. But I stand by my decision. The integrity of the bench can never be compromised.
Well, he's given his answer, Commissioner. Commissioner Baloi?
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes, to go back to a question that was asked by Commissioner Marumakhai, and it was about a discussion about briefing patterns. And I understood you to say that in order to assist with changing the patterns of briefing, your training, and it's about networking and people putting themselves out there. Now, I want to raise the issue with you from a different perspective. It seems to me that the bench should have a different interest to change briefing patterns different from to what my interests are. And different in this way, that the bench is supposed to have a vested interest in training for the future bench. And I was hoping that when Commissioner Marumakhai raised the issue with you, you would answer it from that perspective. What it is, if you were appointed as Judge President, you would do to enhance or to assist with changing the briefing patterns so that the bench of the future benefits from that. We've heard from the AJP that she's had to import people from outside the province because, in her words, I think, there aren't, because she couldn't find enough or at all capable black women, African women, to act, and she's had to get them from outside. Now, I would like to hear your thoughts about what it is you, if you have thought about it, you would look at doing in order to correct that, of course, in the long term, in order to have options at choosing people for your bench.
Thank you, Commissioner. Ongoing training is vital and important. But more particular, the ongoing training must be to that extent that it also fill in the gaps. And as, if recommended as Judge President, that is one of the things that I will look at. As the Commission will probably know, there are various training programs by SAJE for aspirant women judges, ongoing. And that is to be supported in that regard. The role that I'm currently playing, in the meantime, for being on the bench as a leader, is to actively get involved with the moot courts, whether it's from the bar, whether it's from students, whether in fact, we were at a meeting with UNISA some time ago, where this particular same issue was raised. And we said to the body there that they must come and tell us what it is and how we can help them in that regard, in terms of continuous training. Because, as we all know, that UNISA is part-time studies, and we engage with these bodies on a regular basis. So that is definitely where I'm sitting currently, an issue that I will deal with. And not only in terms of the advocates, etc., but also the magistracy. I go out with regard to training for the magistrates as well. So there's an ongoing process that we have to deal with.
Thank you, Susan. Commissioner Mangan?
Chief Justice, adequately covered by Commissioner Baloyi and Commissioner Mima.
Sorry?
My questions were adequately
Also, you've been
raised,
covered.
yes.
Thank you, Commissioner. Commissioner Nokes, you asked a follow-up
Chief
question.
Justice, I've been covered.
You covered, okay.
Yeah.
Commissioner Steinberg?
Sorry, I'm taking you back, Chief Justice, because it was a follow-up from much earlier. I want to ask you what your position is on the taking of minutes at judges' meetings. What do you think is proper?
Sorry, can you just repeat that, Commissioner?
What is your position on the taking of minutes at judges' meetings? Judges' meetings? What do you think the proper procedure should be?
I've got no difficulty with that. I mean, if we can have a recordal of what transpired and the important decisions we take, it can only benefit the division. We can always go back and say, but listen here, 3 months ago we decided this, why have you changed this? It's accountability. It keeps us accountable as leaders. So, and it should be. I mean, as a leader and want to be accountable, somebody must say, but listen here, you decided that 2 weeks ago and you just now decide something else. How can you do this? On what basis can you do this?
So in your position as acting DJP, did you raise that issue squarely?
I was not in that meeting when it occurred. I was on circuit, Commissioner.
But
I mean, that is...
Why did you need a meeting to raise the issue?
No, I raised it. I raised it.
You raised it with the acting JP?
Yeah.
And what was her response?
Because he don't want minutes to be taken.
Excuse me?
No minutes to be taken because that has been, apparently, according to her memory, I'm speaking under correction here, when she was appointed as a judge, she took minutes. And then there was some story about someone else must take over the minutes, and then there was a decision that the minutes shouldn't be taken.
So you're saying this is one of those issues where there wasn't anything postponed, you had one view, the acting JP had another view, you squarely raised your view that this is important for accountability, but she declined to implement it. Is that what you're saying?
Yeah.
Thank you.
Did you say yeah?
Yes, sir. Sorry.
Okay. I'm hard of hearing, sorry. Commissioner Hassan?
Thank you very much, CJ. Potential follow-on, but maybe a little bit different. Just to clarify, to preface my question, acting DJP, how long have you been acting in the position?
Since April of last year.
April 2023?
Yes.
Perfect. I'm interested, and it's an interesting point because it would appear that you've been the only candidate that's acted in the position of DJP. And I'm interested to know about your thoughts around leveling the playing field and giving exposure and opportunities to others, whether you have ever raised with the acting JP that others should also be given an opportunity to act in your current position. Let's start there. Have you ever raised that?
I raised it squarely.
So you have raised it
I've
with...
raised it with a...
All right, and what was the response from the AJP and your subsequent, I would think, response to that?
Subsequent response was she found it difficult to work with any of the other senior judges for reasons that she advanced. And she's of the view that with regard to my temperament, the manner I deal with issues, she feels more comfortable to work with me.
Thank you, CJ.
All right. Thank you very much, Judge A Le Grange. We've come to the end of your interview. You're excused.
Thank you, Chief Justice.